Right. When did you enter the property? Was that on the 24th of March?
Yes, Judge.
Now, there's still some stuff of hers there, is that right?
All the stuff was in such a bad state of repair, I just kind of made the assumption that it was all damaged stuff and it all just went in the skip.
And you've spent, I think, in total, and you've provided me with a breakdown of everything, on skips, cleaning and repairs to the property of £4,501.95, correct?
Yeah, so that's to include full kitchen, a bathroom, all the skips, the garden, which is...
What's wrong with the garden?
There's a massive tree outside the front door which should be tended.
Where in the tenancy agreement is it required that she pay for the upkeep of the garden?
Paragraph 3.18 in the tenancy agreement.
I'm troubled that the court, who effectively granted you an order for possession of the property on the basis of her failing to pay rent...
We never went to court because of the failure to pay rent. It was just we wanted vacant possession to be able to sell the house.
On the basis that the contract had finished?
Just on the basis we wanted it back to put the money into other ventures.
Had you disclosed anything about the state of the property?
No, we kind of... That was just a byproduct that we were going to have to fix later.
Where can I see that it is £1,214.43 outstanding? What evidence have you got?
I'd have to get a massive ream of bank statements. We've got a few letters that tell her up to a certain point how much she owed, and Claire was happy with that.
I've seen that in the letter and the various correspondence, that rent is partially paid by housing benefit on your behalf. I understand that. Not interested so much in the rent, you've made some effort to pay it. That property has been damaged beyond recognition. Why shouldn't you pay for it? Now, madam, I hear your silence. However, there is one important part here. Part of your reply, which I assist you with and construe in your favour, is as follows. You say that you were not given adequate opportunity to go back into the property to collect things which may have been of value to you.
That is true.
Now, sir, she left that property and gave you notice on the 21st or thereabouts.
Yes, Judge.
Before you started putting things in the skip, what notification or communication did you give her or anybody connected to her that you were about to start throwing things away?
Well, on the day that I was going down, after the 21st, I texted Claire to say, I'm coming down, can we meet, to give me the keys back? And there was no response. I texted 2 or 3 times. But then when I broke into the house, everything was in such bad state of repair, I just kind of made the assumption that they'd gone, and those bits could have got thrown away.
Now, in respect of the bits, Claire, you do have a complaint. There were things in that house, one thing in particular, that you lost, you say, because you were not given sufficient notice.
Yes, Judge.
What was it that you lost?
In the bedroom window, I had a little box, because my son passed away about 7 years ago, and it had, off his flowers on the grave, I kept the little cards. And they was in the window and I can't replace them. I think there was other things in there, like a set of clothes what he had last worn, and I can't get them back.
What does it do to you to have lost that particular box of memories?
It hurts. It does hurt because I'm not going to get that bit of memory back.
Did you see the property there?
Absolutely not, Judge, and if it was of that importance to Claire, I'm sure that would have gone with all the other stuff that she had taken, rather than leaving it in the house.
Understood.
There
was nothing of any value there.
What's the state of things now? How are you doing?
Well, I'm still in temporary accommodation with me and 4 children in one room, so it's hard.
Is the house back to repair?
Probably halfway through the renovation process now, Judge.
Even if you had not signed that document, you still would have had a duty of care to take reasonable care of his home, his house. You did not do that. Therefore, all of the damages that you and or your family caused, you are responsible for, both personally, but importantly for this case, financially. In addition to that, the rent that hasn't been paid, despite you having tried your best over a long period of time, is also owing in this case. And despite your difficulty, the court can only give a ruling based upon the law. And the law tells me that I can only do one thing, which is to grant David's application for rent and for all of the damages to the property. In the circumstances, therefore, David, I have no choice but to grant your requested application for £5,000, and that's the award of this court. For more Judge Rinder cases, click here. And if you've got a legal issue yourself, get in touch with us by clicking over here.